Many employers complain that the deck is stacked completely in favour of the employee in terms of employment legislation in Ireland, and that it's practically impossible to dismiss an employee because the employer is being left open to expensive, costly claims for unfair dismissal. In this video, I'm just going to look at the circumstances in which you can, or which an employer can legally dismiss an employee. The first situation is during the probationary period. This is a period that is essentially to allow both parties to assess whether they are right for one another or not, but in particular for the employer to see whether the employee is right for the company or not. Generally, a dismissal during probation is unproblematic. However, there are exceptions to this. Any dismissal that's related to the pregnancy of an employee or, for example, trade union membership, these dismissals, even during probation, can lead to a dismissal, an unfair dismissal claim, a successful unfair dismissal claim. But by and large, there's a common law right to dismiss. So the common law, the courts have recognised that an employer has a right to dismiss an employee for good, bad or no reason. The protection from employees, the huge protection for employees, comes from statute. For example, the Unfair Dismissal Acts from 1977 to 2005. But to benefit from this protection, the employee must have 12 months service in the job. The legislation, the Unfair Dismissals Acts 1977, also sets out what are fair dismissals. So fair dismissals would be dismissals which would be carried out on the grounds of capability, competence, qualifications, conduct, redundancy, or an employee not being able to do the job required due to non-compliance with the law, for example, holding a driving licence if he or she was a sales representative or perhaps a professional driver. So what comes under the category of capability? Absence through illness might lead to a dismissal on capability grounds. Persistently poor timekeeping might lead to a fair dismissal. Documentary evidence, though, would be required for the employer to safely justify a dismissal on the grounds of capability. Competence is another broad category. In order to fairly dismiss an employee on the ground of competence, the employer needs to set out the employee's shortcomings, needs to point out the required improvements, give the necessary time to make the improvement, or sometimes certainly a reasonable amount of time to make the improvement, and to warn of the possibility of dismissal. Conduct then is another broad category which may lead to a fair dismissal. You're looking at a situation of misconduct or perhaps even gross misconduct. It will depend on the particular circumstances of the employment. The employee is still entitled to fair procedures and natural justice unless summary dismissal is justified for gross misconduct. Gross misconduct would want to be pretty bad, though, to justify a summary dismissal. Qualifications then is another broad category of fair dismissals. If an employee, for example, lied at the interview situation about qualifications that he or she held, then that will lead obviously to a fair dismissal. Also, there may have been a job offer made subject to a particular precondition. In other words, perhaps passing an exam or just showing a diploma or a degree or whatever. So that will lead to a fair dismissal. Redundancy then is a defence to an unfair dismissal claim. That's provided that it is genuine redundancy and not a sham. So you need to be careful there, because if the job happens to be filled again by somebody else relatively quickly afterwards, well then that's going to lead the inference, or that it wasn't actually a genuine redundancy, that it was only a sham attempt to get rid of somebody unfairly. Illegality then will lead to a fair dismissal. This would be in a situation, for example, where a sales rep or a lorry driver excuse me, or somebody of that nature was simply unable to do the job because they've lost their licence, or indeed it would cover any other situation where there is a legal requirement for a person to have perhaps a particular qualification or fulfil a particular condition. If they're not able to fulfil it, well then that could lead to a fair dismissal situation. What you'd need to do there, though, certainly if you're an employer, is see is there any alternative work that you could offer. So the fair dismissal or the dismissal should not be the default course of action. You should look around to see is there alternative work that the person could carry out if there's any accommodation that could be made, particularly if the illegality, for example, losing a license, wasn't for that long, Then there's a general category of other substantial grounds provided for in the Unfair Dismissals Act of 1977. Essentially, it provides for dismissal on other substantial grounds. However, my view is that if you're unable to ground your fair dismissal in any of the other categories, then I cannot really see circumstances where other substantial grounds are going to save you from a claim for unfair dismissal if you're an employer. In other words, you need to have your dismissal grounded in one of the other categories that I've looked at in this video. In conclusion, I would advise you, if you're an employer, that the substantial grounds must exist to justify the dismissal. That is the legal position is provided for in the Unfair Dismissals Act 1977. You also should provide fair procedures and natural justice to the employee. Every employee has a constitutional right to fair procedures and natural justice. My name is Terry Gorry. I'm a solicitor in Enfield and County Meath. I do quite a bit of employment law. If you found this video useful, I would appreciate if you gave it the thumbs up, just like it below the video here on YouTube, or stick a comment in the box. Thanks a lot.